On April 18, 2023, you testified before a subcommittee of the House Energy and Commerce Committee. At the hearing, Chair Rogers asked you, quote, "Are there any instances where you have not followed the DAO's advice?" End quote. You responded no, and you followed up by saying that you, quote, "have consulted with the DAO and taken actions that are consistent with the legal statements that DAO has made," end quote. On June 16, 2023, a Bloomberg journalist published a leaked memoranda written by the FTC's DAO analyzing Chair Khan's ability to sit as a judge in the FTC's review of Meta's acquisition of a company called Within. According to the ethics memoranda, the DAO, quote, recommended you recuse to avoid an appearance of partiality concern pursuant to federal ethics regulations. Do you believe that you were completely honest and forthcoming with Congress when you asked if there were, quote, any instances where you had not followed the DAO's advice, and you answered no? Yes or no?
What happens when a top government official is accused of ignoring ethics advice and possibly misleading Congress? That's exactly what happened during a heated hearing with Lina Khan, chair of the Federal Trade Commission. The issue: a major antitrust case involving a tech acquisition and whether Khan should have stepped aside. Here's where the controversy begins. Khan previously told Congress she followed ethics advice from the agency's ethics officer. But then, a report by Bloomberg revealed an internal memo suggesting she should recuse herself to avoid bias. She didn't. During the hearing, lawmakers pressed her with a simple question. White right-pointing backhand index, did you ignore that advice? But Khan didn't give a clear yes or no. Instead, she said, she had no financial conflicts. No ethics laws were broken, and decisions were legally sound.
I need you to answer the question that I asked. The question that I asked was, did you receive different oral advice than what was written in the memoranda from DAO? Very simple question.
So I consulted with the ethics official. The ethics official, as was noted in the memo that you cited, although I did not receive that memo, noted that the ultimate framework for instances in which somebody has no financial conflicts of interest.
Did she give you different oral advice than what was in the written memoranda?
The legal framework
yes or no?
is for the employee to themselves determine whether they should or should not recuse.
Did she give you different advice than what was orally than was in the written memoranda? Yes or no?
Congressman, as was noted in the written memoranda, there was no ethics violation created by my participating in the matter.
But you didn't follow the DAO's advice, did you? You could have recused at any time, couldn't you?
I followed the determination that there was no ethics violation.
You could have recused at any time, couldn't you?
There was no violation under the ethics laws because I have not a penny in financial stock, not a penny in financial interest.
The DAO gave you the advice to recuse and you did not do so, correct?
Congresswoman, as was noted in the memo, as I noted in the letter.
I'm going to move on since you're not willing to answer my question. I read your 4-page letter, which was nothing more than an affront to your obligations of honesty, integrity, and candor before this tribunal that is owed by every public servant. And I would reference Part 2635 of the Code of Federal Regulations, which describes your ethics standards. I want to note that the ethics standards are actually higher than one owed by lawyers, which brings me to my next point. Do you expect lawyers at the FTC to follow federal ethics rules?
Of course, everybody at the federal.
Do you expect lawyers at the FTC to be an active member in good standing of a bar of a U.S. state?
If they're practicing as a lawyer, they need to be in good standing with the relevant bar rules.
I understand that you were admitted to the New York bar on July 16, 2020, but in 2019 and 2020, according to your Senate questionnaire, you held yourself out as counsel for the Democrats on this very committee. You used this title, but you were not licensed to practice law. Counsel is a term reserved for lawyers, licensed lawyers. And in Wyoming, a person who in any manner holds themselves as competent to practice law without a license to do so is guilty of unauthorized practice of law. I believe the law in the District of Columbia where you held yourself out is similar. Do you believe it is appropriate for non-lawyers to claim the title of counsel?
Congressman, when I had the honor to work for this committee, I complied with all of the document requests that the HR folks requested, including documentation about the fact
when
that
I checked your registration status this morning, I learned that you are not in good standing with the New York bar. Your license is listed as delinquent, which means you have failed to file your biennial registrations, and it means that you have not been paying your bar dues, completing your continuing legal education, and maintaining your law license. I believe it's shown on the screen. It also means you're subject to referral for disciplinary action. I find this situation to be stunning and a reflection on your ethics. With that, I yield back.
Should officials avoid even the appearance of bias? Is following the law enough? Or is transparency just as important? The hearing ended without clear answers, but the debate is far from over. So what do you think? White right pointing backhand index, should Lina Khan have stepped aside? Or did she act appropriately? Comment below. White down pointing back.